I've been one, damn it, dolls.
All right, confirm the live stream's begun again. We are back on the record on KCR 2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th. I've considered the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor. And I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. And I'll just quote that section. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell, importantly, does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases. And while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the 2 concerns here raised in the motion really are, number 1, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client, although it may be difficult and he apparently will not be able to be compensated. It's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today. And I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge. Thank you for your consideration.
All right, thank you. Ms. Blake, any questions on the court's ruling? All right, thanks everyone for your attendance. That will conclude today's proceedings. We'll be in recess.
All right.